Atkinson, Anderson, Loya, Rudd, and Romo. Jonathan, I'm going to use your intro from last year. Go ahead and throw a shoe at me if this is wrong. He advises employers in various labor and employment law matters, including drug testing, mass layoffs, warrant, disparate impact analysis, immigration compliance, trade secrets, privacy, technology in the workplace, piece rate compensation, municipal and state sick leave, local, state, and federal minimum wage, and the Patient Protection and Affordable Care Act. Did I leave anything out?
I think you got it all. Thank you, Josh.
Awesome.
All right. Well, thank you. We've compiled a great panel for you today. And I was in the Midwest last week and on vacation, and noticed a peculiar thing as I was driving around. They say in the Midwest that there's two seasons, the winter and construction season. So we ran into a lot of construction driving on the 94 up to from Chicago to Minneapolis. But when there was a lane closure, I noticed something strange, that all the cars would merge into the lane that was open way ahead of time, and there was nobody, rushing all the way down in the open the last minute. Which, if any of you have driven in California, which I'm sure you have, would be the case that we would have two lanes trying to go into one all at the last minute, and maybe even other people in the exit lane and the emergency lane trying to get around that traffic. So that's just to say that in California, we have a way of life that is peculiar to California. And our topic today, focusing on arbitration, is one of those areas that is very unique to California as to how the law has developed. So we've got a great panel for you today to discuss that with you. First off, we're going to have Roger Crawford speak. Then we will have Jennifer Kramer speak, and then we'll have the Honorable Judge Michael Marcus speak on the topic and their experiences with arbitration. So our first speaker today, I'll go through the bios right now, and then we'll open it up to the panel. But Roger Crawford is a partner with Best and Krieger. He advises both private and public sector employers in all aspects of labor and employment law, focusing on labor negotiations, the interpretation and enforcement of collective bargaining agreements, and unfair labor practices, and also representation matters before the NLRB and PERB. Prior to his time with BVUK, he was a field attorney with Region 21 of the NLRB. And outside of his practice, Roger is an obsessed Tottenham Hotspur fan. Next up, we have Jennifer Kramer, who is our managing partner at Hennig, Kramer, Ruiz, and Singh. Her practices focuses on complex employment litigation on behalf of employees. Jen currently serves as a member of the board of the California Employment Lawyers Association, and in the past as the chair of CELA's Wage and Hour Committee. When she is not advocating on behalf of California workers, Jen will be found in her garden, tending to her California native plants. Very important in today's drought environment. And then finally, we have Judge Michael Marcus. He has been a mediator, arbitrator, and discovery referee for ADR services in the last 20 years. He has mediated over 4,000 cases, arbitrated over 100 matters, and was recognized for the 6 consecutive years by the Daily Journal as a top 50 neutral. Judge Marcus is a prolific author, writing on mediation, civility, trial preparation, legal ethics, prosecution discovery, and the destruction of evidence, and also writes for the California State Bar. He has taught evidence at USC Law Center, go Trojans, but he graduated from the University of California, Berkeley, and attended UCLA law. So he's been all over the state with his legal career. So thank you, and I toss it over to Roger to start our session.
So I think to start off, there's an obligatory come on you Spurs. So to start off, I think the audience here and most of the people who are attending have a lot of experience with arbitration, but they have arbitration based under collective bargaining agreements. And so that's what I'm going to be really talking about today. And not just that, but really the aspect of where it kind of meshes with the private sector, or not just the private sector, but the non-unionized sector, where employers, have arbitration agreements either in their policies or in their, somewhere with a mandatory arbitration agreement with employees. It's obviously different in the collective bargaining arena, and I think it's an arena that you're more familiar with. But what I really want to focus on is those aspects of collective bargaining agreements or arbitration out of collective bargaining agreements, or in the public sector, it's going to be memoranda of understanding, same thing, that deal with requiring employees to arbitrate statutory and perhaps state common or federal common law claims, as opposed to being able to take those ones into state court or federal court, for that matter. I think the starting point is, and I always ask, why wouldn't, and I'm talking from an employer's perspective, but I think it's the same side on, it should be the same question that people should be asking on the other side when they're negotiating a collective bargaining agreement or a memorandum of understanding. Why even enter into one that requires employees to arbitrate or could arbitrate these types of claims and everything? I think there's kind of a mantra that goes along with non-unionized employers that we want the arbitration agreements, mandatory arbitration agreements are good. Obviously, the state of the law there is changing, and Jennifer's going to probably have some talking about that. But there's this mantra that employers have, and I'm not always sure that the conventional wisdom behind that is sound. I think before entering into, and it's probably for both sides, entering into an arbitration agreement and as part of a collective bargaining agreement, or as part of a memorandum of understanding, or even outside of that, there really needs to be some serious thought into is this what you really want? I think from an employer's perspective, some employers might want that because they just, like I said, they think that it's in their interest. I think a concern about having that employers might have is, especially in a collective bargaining agreement, that they wonder if including statutory claims as things that are required to be arbitrated, as opposed where an employee can go to state court over, that they're inviting claims that they otherwise wouldn't get. I think when you have a grievance and arbitration procedure, there's perception, and I think there's some merit to it, that it's a lot easier to file a grievance and go through that procedure, for an employee or a union to go through that procedure than it may be to actually go through the hurdles of hiring a lawyer and going into state court. So I think some employers might be adverse to, including that language in their contract, because they think they may be inviting claims that they otherwise might not get. I think also the same thing, on the flip side, employer, there is this mantra, like I said, conventional wisdom that you want to have these claims in arbitration over outside of state court, because arbitration is a cleaner form to arbitrate these claims. It's less expensive, it's more speedy, it's quicker. And I think that's generally true, but I think you need to analyze that and think it through, because there may be certain types of claims, especially those that are real discovery intensive. I would think about harassment types of claims. And of course, the field is changing there on that. But I would think there are some claims that are very discovery intensive, and sometimes arbitration may not be the best course. And then also, I think as practitioners, if you're advising an employer, and I think that might be same true on the other side of the aisle, you have to look at the client. I look at my clients and I think, is this the kind of client who's going to want to go rogue, go on their own, frankly, in some situations when I've got a client who's going to go rogue, especially on discovery issues, I might want to be in court because there might be a little more forgiveness there. There might be an appeal process when we get some, awarded against us. There might be, there seems to be sometimes more flexibility, but, and I'm not saying that's necessarily the case. I think those things are things that you need to take into consideration when deciding this. Arbitration of statutory claims in the collective bargaining arena really are a beast of the contract. I mean, that dates back to the Steelworkers Trilogy. It's the 14 Penn Plaza matter case. It really comes down to the beast of the contract. And this is where I think an awful lot, there often ought to be an awful lot of thought in this too. When I look at it, I think there are really two issues. When you talk about whether or not a particular statutory claim can be mandated or required to go through the arbitration, one really relates to the 14 Penn Plaza US Supreme Court case. And that is whether there is a clear and unmistakable, and those are the words you got to look at, clear and unmistakable agreement to require that the claim in question, the matter in question, be subject to the arbitration, to mandatory arbitration or to the arbitration clause. The other one is there's a federal preemption under the Labor Management Relations Act. To what extent, even if there may not be a clear and unmistakable agreement to include this claim in the grievance and arbitration procedure, there may still be some kind of argument that it's still nevertheless preempted if it requires the interpretation of a contract. So those are the two primary areas that we look at. With regard to the first one of the clear and unmistakable agreement, it really looks like the cases are coming down to, if you want to have and you want to feel confident that you have a clear and unmistakable agreement to include a statutory matter in the grievance and arbitration procedures, you've got to include that in the grievance and arbitration procedures themselves. There's a case, I think, where the argument was, and the claim was over a national origin discrimination claim, and whether or not the employee who wanted to bring the national origin discrimination claim had to file that had to go through the arbitration process, or was required to pursue that through the grievance and arbitration machinery in the contract. And in that case, basically what, it's like most collective bargaining agreements, like most memoranda of understanding, they generally have a provision, a non-discrimination provision, where both the union and the employer agree not to discriminate on the basis of a list of protected classifications. But the arbitration agreement, the grievance and arbitration provisions in itself did not say that a violation of that provision was subject to the arbitration clause. It may have said that a violation of the contract itself is subject to the arbitration clause, but it's not. And in this particular case, the court came down and they basically said, well, it wasn't in there. So it wasn't a clear and unmistakable agreement to include that matter in the arbitration. And so they allowed the employee to pursue the claim in court. And then when you look at the preemption side of it and everything, there's a question, you had an arbitration and you had a contract that precluded discrimination on the basis of, among other things, national origin. And the contract itself, so it precluded that. But in order for it to be preempted by the LMRA, they had to have some kind of actual dispute over the interpretation of the contract. And in that, and the court in that, then on that issue basically said there wasn't a dispute on that. Neither party had differing opinions about whether this non-discrimination clause in the contract precluded discrimination on the basis of national origin. Nobody is really disputing that language. There wasn't a dispute over that. There may have been a dispute over whether or not the actual facts are, constituted national origin discrimination. but it wasn't a dispute over the contractual language, so therefore it wasn't preempted. That being said, I think it really comes down to a number of things. So I think if you want to include something in the contract, or if you want to include or require, arbitration over statutory claims, I think the bottom line is you need to include that language clearly in the grievance and arbitration language of the contract. How you define a grievance and how you define what grievances are arbitrable. I mean, I've seen actually contracts before that will list those matters, say they've got matters of A through F, and there's listed them, and those are, those matters that can be grieved, valid grievances. But then I've also seen contracts that will say, yes, we've got A through F, but only A through D are those that you can take to arbitration. Grievances over E and F have some kind of other mechanism for resolution. If you want to require arbitration over a statutory claim, the best thing is to actually list the statute itself. There's a matter where there was a dispute over the contract actually listed. This is the Cortez case where the dispute actually. So this is, kind of gives you an idea as to where these lines might be drawn going forward. If you don't include something, like, for example, gender discrimination or FIHA claims in the arbitration clause, or the definition of what constitutes a grievance that can be arbitrable, you might not be able to require arbitration over that, even though you might have a non-discrimination clause in the collective bargaining agreement. On the other side, there is the case where the grievance and arbitration clause clearly defined as an arbitrable matter or dispute a violation of wage order 16 of a wage order. But what it didn't do is it didn't list a violation of the labor code. And so the question was, well, the claim was brought under the labor code for minimum wage or overtime claim. I think it was a minimum wage claim. The claim was brought under the minimum wage, under the labor code for minimum wage violation. And the argument, the employer in that case argued, well, this is subject to mandatory arbitration under the collective bargaining agreement because it's a minimum wage claim and we've listed the wage order. But the actual lawsuit itself did not file a lawsuit under the wage order, file a lawsuit under the labor code. And in that court, and this is the Cortez case, they came down and said, well, yes, but the reality is if you want to pursue a claim for a wage order violation, you have to, as a practical matter, do so through the labor code, through a labor code. That's your cause of action when you file your complaint. And so they said that's one exception of it. But the reality is, that case actually, and I always tell my clients, if you have to go to court over something like that, even at the end of the day, you win, you kind of lost because you end up spending a lot of time and expense litigating this. As for practitioners who are negotiating these agreements, if we want to have something that's subject, a statutory claim that's subject to that, and for what it doesn't matter what your opinion on 14 Park Plaza, I know there's a lot of disagreement on that, but you've got to include it in there. I think on some issues that I've gone up and some experiences that I've had where you've got some ambiguity, and I understand that, like I said, what you're able to negotiate in a contract is a creature of lots of things. Obviously, it's the relationship between the two parties. It's the history of between the two parties. I also certainly understand that, as much as I, as a lawyer who wants to interpret this stuff and enforce it and arbitrate it and everything, I want clarity. I've also negotiated labor agreements, and I realized at the end of the day that sometimes you have to settle for ambiguity. And that may be the best that you can get. But it's something that but I also think that even if that's the case, that should be a conscious decision. You should realize that that's a conscious decision you're making. We're giving up, some certainty for ambiguity because that's what's going to get us the deal. That's the sacrifice we have to have. I think that's a probably on both sides in the negotiation aisle. That's something that goes on. That's what people are contemplating. I'm concerned a lot of the times, but it's not really thought through. I think the one horror story I have is we had a client, this is a public sector client, and they had a grievance and arbitration procedure. And this was an employee termination. We went through to arbitration. You know, we were successful and the termination was upheld. But the grievance and arbitration procedure, instead of using the word arbitration, they used mediation in it. But they used the word mediation, but when it was exactly a substitute for arbitration throughout the memorandum of understanding. And I think what that was is the negotiator at the time, in order to sell it to the client and everything, arbitration to the client, for some reason, the word mediation was more palatable. And so that's what they agreed to, not thinking this through. Subsequently, they said that the mediator's award, you know, like I said, so the contract used mediator, but talked about the selection of the mediator, knocking off names of a list of 7. You know, talked about the procedures, the presentation of evidence. Then it went on to say that the mediator's award was final and binding, which to me sounds like arbitration. But it said final and binding, except for, and I'm paraphrasing right now, except for, you know, whatever procedure you want to file under the Code of Civil Procedure. Didn't say Code of Civil Procedure 1286.4, it said under the Code of Civil Procedure. So, you know, we ended up getting a favorable award. And the next thing we know, we're in Superior Court over it. And we had to argue, spend a lot of time and expense arguing that, yeah, we use the word mediator, but for all intents and purposes, it really means arbitration or arbitrator. And then when it said code under civil procedure, yeah, that's what we use. It really meant, you know, 1986.4, we weren't talking about a writ of administrative mandate under 1094.5 or anything like that. It doesn't really fit in the scenario, but it was an argument and a fight. At the end of the day, it was successful. But I think it's things like that. I mean, so like I said, I understand at the end of the day, sometimes you have to settle for ambiguity, but really in these matters, you need to make a conscious decision for ambiguity and not make sloppy mistakes like that. And be honest with the client that, you know, when the client doesn't like the word arbitrator, but you want to settle for mediator instead, you need to be honest with the client saying, here's the problems that could be caused by that. And it's really the same thing. And so I think that's, you know, that's probably what I close with. I'll turn time over to Jennifer, but you know, my closing point would be, in the collective bargaining arena, whether it's public or private sector, this is really, you know, it's really a beast of the contract itself, and it's really a beast of the actual language that you have. Anyway, I think that's it. I'll turn it over to Jennifer now.
Okay, thank you, Roger. I had a question, a follow-up question that maybe Jennifer can answer too in her session. But do you find, or do you think there's a wider latitude for picking and choosing what claims are covered by a arbitration provision in the CBA context rather than in the non-CBA context?
I do, because I think, you know, there are some situations for in the CBA contract context where, you know, and maybe there's room for this as an open area for litigation down the road, but you know, keeping us employed. But I think that there is, because you're negotiating it. It's a negotiated agreement. Where I think in the private sector client context, you know, obviously the law is changing, and Jennifer can answer this, you know, or address this if, you know, it's appropriate. But I think in the non-union context, having an arm's length negotiation with an employee is a lot more difficult to justify or sustain from an employer's perspective, or maybe from any perspective. Whereas when you're in the collective bargaining, you know, negotiations, you know, they really are arm's length negotiations.
All right, thank you, Roger.
All right. Should I dive in then?
Yes, please.
So I'm going to talk about what's generally referred to as pre-dispute agreements to arbitrate. as the plaintiffs bar and now the US Congress refer to them, they're mandatory forced arbitration provisions. And so this is in the non-union setting. This is governed by the Federal Arbitration Act, which is found at 9 USC, starting at Chapter 1. And the FAA applies to written contracts involving interstate or foreign commerce. The FAA was enacted because of a perceived hostility to arbitration by the courts and a perceived need to place arbitration agreements on the same footing as other contracts. There are two major exceptions to the FAA. First, in the non-union setting is for transportation workers engaged in the interstate transport of goods. And there's been a few cases from the US Supreme Court during the last few years laying that out. Sort of the groundbreaking one was New Prime versus Oliveira, and that I think is in your materials. What came out this year from the US Supreme Court was Southwest Airlines versus Saxon, which further expanded the scope of what it means to be a transportation worker engaged in the interstate transport of goods. These were baggage handlers moving baggage from an airplane to the terminal, and the US Supreme Court found that, well, the worker wasn't actually moving in interstate commerce, they were transporting goods that were moving in interstate commerce, and so therefore fell within the exception. And there was another case last year from the Ninth Circuit that further clarified this. This is the Carmona decision that's in your materials that talks about delivery drivers who are moving goods intrastate from a warehouse to a franchises of Domino's Pizza. And even though the drivers themselves weren't moving interstate, they were still moving goods that had moved interstate. So they fell within that exemption as well. The main area where we see this in my practice is what we call the Amazon last mile drivers. These are people who pick up your package from the Amazon warehouse and bring it either to your residence or to a commercial business. And those drivers are generally found to fall within that exception as well. The other exception is a new one. As of March 3rd, 2022, claims for sexual assault and sexual harassment are also now an exception to the FAA. And it's called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. We refer to this as the Gretchen Carlson Act. This arose from her claims of sexual harassment and sexual assault against Roger Ailes while she was at Fox News. And a coalition of Republicans and Democrats came together to carve out an exception to the FAA for sexual assault and sexual harassment cases. And in doing so, the Congress adopted the language that the plaintiffs' bar has been using, which is mandatory forced arbitration. And then NELA, the National Employment Lawyers Association, has been lobbying for years and will hopefully now be getting traction on passing the FAIR Act, which would create an exception in the employment context for arbitration under the FAA. So why is this a disfavored forum by workers? You know, I'll start with, there was an excellent study by the Economic Policy Institute, and it showed before the 2000s, only 2% of workers were subject to these clauses. After there was a series of US Supreme Court decisions blessing forced arbitration, that number has gone up to 68% of California employers now mandating arbitration as a condition of employment. And arbitration is, a wonderful tool when both parties are freely choosing it. But in contrast, workers are forced to sign away their rights when they get hired under the 7th Amendment to a jury trial. So when they're required to use the employer's handpicked arbitration system, where there are often few advantages for the workers. Workers have minimal to no experience in the arbitration system. Studies show workers are less likely to be able to find an attorney to represent them in arbitration versus court. Workers have less access to information to select arbitrators. Arbitrators often take multiple cases from the same employer or same defense counsel. We refer to this as the repeat player effect, where the worker will typically only use the arbitration system one time. And then often discovery is limited in arbitration cases where in employment, the employer typically has possession of most of the critical documents, and it's the worker who needs to depose more individuals prior to the hearing. And so the limitations on discovery more greatly impact the worker than the employer. So all contract defenses apply to arbitration provisions. Again, these are just contracts that are placed on equal footing with all other contracts. The most significant decision to come out in this area in California is the Armendariz decision, which is in your materials. And this sort of laid out the standards for arbitration in California statutory employment disputes. So for example, under the Fair Employment and Housing Act and under the Labor Code. First, there are 5 minimum requirements for any arbitration in the employment context. First, a neutral arbitrator. Second, a provision for adequate discovery. Third, a written decision following the hearing. The costs of to be borne by the worker are only those that they would face if they were in civil litigation. So the employer pays for most, if not all, of the costs of arbitration. And there can be no limitation on remedies. The Armendariz decision also sets forth a test of unconscionability for arbitration agreements in the employment context. So you're going to be looking for substantive and procedural unconscionability, and it's supposed to be a sliding scale where if there's more substantive unconscionability, there can be less procedural. So the substantive unconscionability we often see are where they leave out or they contradict the 5 minimum requirements, where the arbitration agreement is unilateral, where there's a confidentiality provision. And then for the procedural unconscionability, we generally always start from a base that these are contracts of adhesion. Case law accepts that that procedural unconscionability exists in most employment arbitration agreements. And so therefore, you're starting from a place of assuming that there was no negotiation of the agreement. And then also, usually where we're seeing a lot of litigation these days over procedural unconscionability is over language barrier issues. So for example, if you're handing a monolingual Spanish speaker an English agreement to sign and giving them no translation, courts will often find procedural unconscionability. So outside of procedural unconscionability, the courts are increasingly taking a closer look at the formation of the agreement itself to determine whether or not a contract was even formed. And I've included a couple of recent cases in your materials. First is the Mendoza case, and there was no signature line for the arbitration policy anywhere in the handbook. There was language in the handbook that said that the handbook was meant to be informational and not contractual. And then the acknowledgement for the handbook didn't mention anything about arbitration. So in that context, the trial court and the Court of Appeal found that there was no formation of an arbitration agreement between the employer and the employee. The other case I've included is the Bannister case, and this is increasingly where we're seeing electronic signatures to arbitration provisions. And this can be particularly troublesome, and courts are allowing there to be actual hearings on the merits to determine whether or not the worker actually affixed an electronic signature. And in that case, the Court of Appeal agreed that the employer hadn't met their burden of proving that the employee actually affixed their electronic signature. So another big development recently in this area was the passage of what we refer to as AB 51. This is codified now in the Labor Code as section 432.6. This prohibits requiring applicants for employment or employees to waive their right to a judicial forum or any other forum as a condition of employment or continued employment. The act itself isn't limited specifically to arbitration, but it does affect arbitration. So as advocated by the backers of AB 51, and in full disclosure, I lobbied on behalf of this bill. The US Supreme Court has never ruled that the FAA applies absent a valid agreement. And so this statute seeks to regulate conduct before the agreement is entered into. So it establishes a public policy that the employment relationship is inherently coercive, as distinguished from commercial relationships. And that arbitration imposed as a condition of employment is not a matter of consent, which is language that's used frequently in cases interpreting the FAA. There is a case filed by the Chamber of Commerce challenging AB 51. It's called Chamber of Commerce versus Bonta, that the Ninth Circuit upheld AB 51. The Chamber of Commerce asked that there be an en banc review of that decision, and that was stayed pending the outcome in a case I'm about to talk about, which is Viking River. So I looked at the docket today to see where the Bonta decision is, and it looks like they've just started rebriefing it post Viking River. So another major exception that existed prior to June of 2022 to the FAA was for the enforcement of labor code and wage order provisions preventing wage theft that's commonly referred to as the Private Attorney General Act, or PAGA. So this imposes civil penalties for violations of the labor code and the wage orders. And the California courts interpreted the PAGA as a claim belonging to the state, who is not a party to the mandatory arbitration policy. And this was referred commonly as the Iskanian rule. The Iskanian rule invalidated contractual waivers to the right to assert representative claims under the PAGA and kept PAGA claims in civil courts since the state was not a party to the agreement. There were a series of post-2000 US Supreme Court cases essentially extinguishing class arbitrations and allowing class action waivers in arbitration agreements. And so PAGA then became the primary mode to enforce anti-wage theft on a representative basis. And this was until the Viking River decision came out in June of this year. So the question presented in Viking River was whether the FAA preempted California's Iskanian rule, which prohibited the enforcement of agreements that waived an employee's entitlement to pursue representative claims under the PAGA in civil court. So there are two major holdings in this case. First, the court was clear that the FAA didn't preempt California's ban on PAGA waivers and arbitration agreements. So PAGA waivers remain unlawful. The second part of the holding is that, however, that the FAA does invalidate the part of the Iskanian rule to the extent that it uses a rule of a claim joinder, precluding enforcement of the arbitration agreement. Essentially, what the US Supreme Court did was divide PAGA claims into individual PAGA claims that go to arbitration and non-individual claims that would stay with the state court, civil court. Other important subholdings of the case is that PAGA representative action claims may not be treated like class action claims for purposes of FAA preemption. And the FAA does not permit employers to use arbitration agreements to strip employees of substantive state law rights and remedies. So even though that just happened in June, there's been a lot of developments. because there is a question about whether or not the US Supreme Court properly interpreted California state law. So first, there's a petition for review at the US Supreme Court, which was taking issue with part 4 of the opinion as misstating California state law. And it asks for those questions to be remanded to a California state court. The first is an issue of the severability clause that was compelling the plaintiff in that case to arbitration. There was a PAGA waiver in that case, which under the holding of Viking River should have been invalidated, meaning her claims should have stayed in state court. Second, there's a larger issue of it dismissed the non-individual claims for a lack of standing on the plaintiff's part. They said that because she signed an arbitration agreement that compelled her individual claims to arbitration, she no longer had standing to represent the other individuals, the other aggrieved employees in a state courts, in a civil court setting. So the challenge in the petition to review is that under the plain language of PAGA, there's only 2 requirements for standing. 1, that you were employed by the violating employer, and 2, that you suffered some or all of the violations. And so there's a challenge on that end. And then the California Supreme Court also recently took up review of a case called Adolph versus Uber. And the issue in there is, again, the standing issue that's raised in the petition to review in Viking River. There are 2 LA Superior Court trial court rulings that have come out recently that agree with the petition to review in both Viking River and Adolph, that the standing requirement as it's laid out in Section 4 of Viking River is an incorrect interpretation of California law, and that the representative action remains in state court. So that's just sort of the state of pre-dispute arbitration. And so I'll turn it over to just Judge Mike Marcus to tell me how I'm wrong about arbitration.
Thank you. Thank you, Jennifer. I'll defer my question for you until the end, time permitting, to give Judge Marcus time to present his presentation. Thank you.
I wouldn't be so bold as to tell you that you were wrong. But, you know, arbitration is kind of an aberration in a way in mediation in California, because I see a lot of cases where there is contractual arbitration, or as Jennifer said, pre-litigation language, and often the litigants are mediating it. And then when I raised the question of, well, what's happening with the arbitration clause? And they said, well, we're not sure yet, we're going to invoke it. That's from the claimant's bar. And I don't raise the issue of waiver at that point. Certainly, as in the case of, which I don't think is in your materials, 17-month delay to enforce or invoke the arbitration clause was found to be too long, and there was a waiver. So it's something where I think the claimant bar is probably not exercising its rights appropriately on all occasions, but they don't want to go into arbitration where they have to have one person decide, and maybe they'd rather have a jury of 12. So that's what's really motivating that particular anachronism. The other thing which I find interesting and strange about arbitration is that there's a policy favoring the enforcement of valid arbitration agreements in both the FAA and the California Arbitration Act, but you wouldn't really know that by reading the opinions. So they will often give homage to the policy, but then they'll decide it didn't apply in this case because of unconscionability or some other problem. Like Jennifer, I think we should start off with Armendariz. in terms of looking at especially a pre-dispute litigation contract, because Armendariz lays out, as she mentioned, 5 different policies or standards to look at. And even though the case is from 2000, and I think the year 2000, but it's still good law. And it's still good law. And Iskandarian is still good law, which is another California Supreme Court case, notwithstanding what has happened 2,000 miles away. And Otto is an example, which again is in your material, had recognized the validity and the viability of Armendariz. So the question, and this is one that I think Roger mentioned, but I think the cases are quite clear on that, is that a provision for a class action waiver that is silent, not enforceable. And that would be the Stolt-Nielsen case from the US Supreme Court case. And then there's the issue of ambiguous language in contracts on the class action arbitration, whether or not it has been waived. And ambiguous language in Lamps Plus, another US Supreme Court case from 2019, holds that ambiguous language is not enforceable. Now, in my opinion, if it's only into one provision, but it's also ambiguous as to others, certainly I think the principle in Lamps Plus can be argued as to the entirety of the contract or the CBA. But at least those are 2 cases to look at. One is Stolt-Nielsen and one is Lamps Plus on either silent language or ambiguous language. We also get into the issue of preemption, and between the FAA and the CAA. And when I was reading the cases again, I was wondering whether the claimant's bar, the plaintiff's bar, is missing a beat by looking at the exclusion language of interstate transportation. And I'll leave that language interpretation to a practitioner, but whether that on an interstate commerce case, that would avoid arbitration, perhaps under the CBA, but would not avoid arbitration under the FAA. Excuse me, the FAA and not under the CLA. It gets a little complicated there, but I was wondering about the kind of the intricacies there involved, that if an employer is arguing arbitration and you've got an interstate issue, perhaps you can avoid arbitration by just looking carefully at the interstate exception recently discussed. Which means, by the way, as an aside, arbitration issues are complex and sophisticated and require people to look at them carefully. First, look at the language, either in the CBA or in the contract, and carefully look at it, because you've got differences of fact between the CBA and the contract, the CLA, or if you've got just language that is unclear. It's my experience that I think that plaintiffs, claimants, practitioners do not pay enough attention to parsing the language. I won't mention Viking River, other than the fact that it's been raised several times recently in mediations. And I'm not going to decide what to do because I'm a mediator, I'm not deciding law. But on the other hand, I think that the whole issue is in disarray, and people are going to have to decide what to do. Obviously, if you want to wait for the California Supreme Court or the US Supreme Court to rule, depending upon the issue, then I think you clearly put down in a brief to the trial court or to the arbitrator, depending on who's reading, who's going to apply the law, that you're not waiving the language, but you certainly, you are waiting for the appropriate court to decide. Otherwise, you might get into an issue of waiver again. I mentioned that Iskanian and Armendariz are important cases. As Jennifer mentioned, Iskanian had to do with PAGA claims, and then there is an issue now as to what's going to happen to a PAGA claim. The other day in a mediation, I had an individual PAGA claim and a group PAGA claim. And the employer said, well, we're going to bring a motion to compel the individual claim. And the claimant's response was, well, I'm not so sure you can do that, but that's where it was left. But it just shows you that these issues now are commonly arriving. PAGA, of course, is a unique provision, not very much appreciated by the employment bar, but a darling of the claimant's bar. And I won't say anything else about PAGA claims, but they are certainly they are a pain in the rear to the employer. Now, when we get to waiver, and we talked about waivers of defense, we talked about Armendariz, but Andian has 6 factors in deciding whether or not there is a waiver. And I'm not going to repeat them, but I think that it's certainly an important case to look at page 375 of the opinion, which talks about the various factors in determining waiver. On the on that fact that and that was the waiting 17 months. That is a case that is not in your materials. That is Martin versus Yasuda, YASUDA, at 829 Fed 3rd 1118, excuse me, not 118. And it said litigating for 17 months before compelling arbitration is a waiver. And that's certainly something to be aware of in your calendars when you're litigating and you've not moved to compel arbitration on the employment side. There are some cases which are interesting about procedural and substantive unconscionability. And one of them is the Torres-Silas case versus Fitness International, which held that the FAA was neither procedurally nor substantively unconscionable because the employee had the opportunity to bargain and discovery was provided for, and the agreement was not overbroad or lacking in mutuality. It sounds a lot like Armendariz. And then we get to, even though that's a federal case, and then we get to the case Alvarez versus Ultimate Health Services. The reason I mentioned this case is because it provides a lengthy analysis of procedural and substantive unconscionability. And if you want to read a recent case which analyzes the whole spectrum, that is a very helpful case, Alvarez versus Ultimate. Then we get into the technical problems, and Jennifer mentioned one of them as an example, I think it was the automatic or the signature of the plaintiff. There are technical aspects of procedural unconscionability which have to be noted. It also includes no Spanish language translation, and that's Alvarez. This is a case unique to any large metropolitan area, whether we're talking about Los Angeles or San Diego or Fresno, Bakersfield, or even San Francisco. If you have a person who does not speak English, and whether that person is from an Asian country or whether that person is from a Spanish-speaking country, there's got to be a translation of those critical terms. And if the person was merely provided a book with all of the policies in it and certain language in a separate document, but that was not in the language spoken by the individual, then there's going to be a problem. And that's, again, Alvarez versus Ultimate, which discusses that issue. And then there's the electronic signature case under Bannister. And I'm going to read what I've noted here because it adds a little to Jennifer's comments. Substantial evidence supports the trial court's conclusion that the employer failed to authenticate the electronic signature on the arbitration agreement as the employees. The employer's evidence did not establish that the employee was assigned a unique private username and password so that she was the only person who could have accessed the onboarding portal and signed the agreement. Instead, the evidence showed that the requisite client ID and PIN code was not employee specific. This is an example of the technical nature of a employment arbitration agreement, which is now a little bit more technical than it was 30 years ago. People weren't signing these things 30 years ago remotely. Now we're getting remote signing. So this again has to be complied with. Interpretations have to be provided. Another language that I saw recently that I thought was kind of interesting was out of the OTO case, which invalidated an agreement because the language was too complex. So if language is too complex, then it could be stricken as unconscionable. Take a look at that. And then I just want to note one case on appealing. An arbitrator error could be the grounds for reversing an arbitration award. And that would be noted in the Pearson Dental case. And so that's for your review of arbitration, which is, as noted in the beginning, a very complex procedure.
Thank you, Your Honor. And I've got a question for all three of you, just to give your quick opinion on. Do you have a preference as to whether a arbitration provision requiring the arbitrator to decide whether something is arbitrable, or would you rather leave that to the courts?
I can quickly answer that. On behalf of the plaintiffs bar, we would like the court to review that issue.
Roger?
That issue can be decided by the parties or by its absence. If the parties want the court to decide it, which is the norm, then so be it. But if the parties want the arbitrator to decide the issue of arbitratability, then look at the Henry Schein case, SCHEIN, which is 139 Supreme Court 524, because then the parties can waive it. So ordinarily it's going to be decided by the trial court, but it can be waived.
And I won't speak on behalf of the employers bar, but I tend to prefer that the courts decide that too.
All right, we got time for a final question, and I think Josh is a big fan of these crystal ball questions. So for the panel, will the Ninth Circuit en banc uphold AB 51 and prohibit employers from signing mandatory arbitration agreements?
Yes, and it will go to the US Supreme Court.
And then what?
And I agree. And then the Supreme Court will roll the other way.
Yes, I agree.
Probably. I mean, you have to remember Viking River is such a weirdly cobbled together. Every section has different justices signing off on it. It's such a mishmash of cobbled together agreements that, you know, I don't know if we can get another majority for AB 51. We'll see.
All right, that'll be a couple of years down the road, it seems. Well, thank you on behalf of Roger, Jennifer, and Judge Marcus. We thank you for attending today, and we'll pass it back to Josh, and our next session will start in 15 minutes, I believe.
Thank you so much to the panelists. Arbitration provisions, as you all know, are a very technical provision, and everyone did such a good job of laying those out. I'm so grateful. All right, so we have a 15-minute break, and then we will return for our keynote speaker. We'll sign off just for a minute, and we'll be back in 15 minutes.
Thanks.